Thumbs up in the back of the room. I'd like to call the meeting to order. I may need some help with the parliamentary procedures to make sure I do this correctly. I'll just make note that our chairman, Bart Howard, is not present today, also our vice chairman, Elizabeth Trinkler, is also absent from today's meeting. So I'm assuming that role to work us through this agenda. So if you don't mind, ma'am, could you do the roll call?
Certainly. Bart Howard. Elizabeth Trinkler, absent. Elizabeth Dixon. Present. Steve Harb.
Present.
Chip Hellman.
Present.
You have a quorum, sir.
Great, thank you. And then our notice of meeting, please.
This meeting's date, time, and location have been noticed on the Tennessee Collection Services Board's website, included as part of this year's meeting calendar since August 16th, 2013. Additionally, the agenda for this month's meeting has been posted on the Tennessee Collection Service Board website since November 7th, 2014. This meeting has also been noticed on tn.gov's public meeting calendar.
Thank you very much. Our agenda indicates that we have a rulemaking hearing, and I suppose we'll move naturally into that, into the rulemaking hearing before we work through our normal board agenda. Is that correct?
Yes, sir, that's correct.
Okay. So do I need to make any special proclamations here, or how are we going to go about that?
No, sir, just a quick vote to convene the rulemaking hearing, and I'll take.
I have a motion to convene the rulemaking hearing.
So moved.
Second.
You had a motion and a second. All in favor, say aye, please.
Aye.
Aye.
Thank you, Mr. Chairman. This rulemaking hearing for the Tennessee Collection Service Board is hereby called to order. My name is Chris Whitaker, and I serve as Assistant General Counsel for the Tennessee Collection Service Board in the Department of Commerce and Insurance Regulatory Boards Division. Would the agency representatives who are present please introduce themselves for the record?
Chip Hellman.
Beth Dixon. Elizabeth Dixon. Elizabeth Dixon.
Steve Harb.
Thank you. Today is Wednesday, November the 12th, 2014. This rulemaking hearing is taking place pursuant to TCA 4-5-204 in Conference Room 1B of the Davy Crockett Tower, 500 James Robertson Parkway, Nashville, Tennessee 37243. The purpose of this rulemaking hearing is to solicit comments on proposed rules the Tennessee Collection Service Board has made public in order to delete all references in the rules to the now non-existent location manager requirement, which was deleted by the legislature in a 2013 amendment to the Collection Service Act, and to create an expedited process for license renewal for certain members of the military and their spouses, also pursuant to legislative amendment. A rule is defined as an agency statement of general applicability that implements or prescribes law or policy or describes the procedures or practice requirements of the agency. Proposed rules are filed with the Office of the Secretary of State, notice is given to the public for comment, and a rulemaking hearing is held. Upon conclusion of the hearing and adoption of the proposed rules, the rules are forwarded to the Attorney General's office to be reviewed for legality. If approved, they are then filed with the Secretary of State, which is responsible for publication, and the Government Operations Committee of the General Assembly. The rules must stay in the Secretary of State's office for a minimum of 75 days, at the end of which time the Secretary of State will list an effective date. Those members of the public wishing to speak should sign in at the table at the front of the room. Only those who have signed in will be permitted to speak, and having received no comments from the public regarding the subject matter of the rulemaking hearing, and I've already discussed that with our guests who will be addressing the board on another matter. The public comment section that I normally read will not apply. The notice of rulemaking hearing, including the entire text of the proposed rules, was filed on September the 12th, 2014 with the Secretary of State, and it was listed in the September 2014 edition of the Tennessee Administrative Register. Additionally, the board approved this rulemaking hearing and the regulatory flexibility analysis relative to these rules on May 14th, 2014. Ms. Whaley, can you please read for the record what additional notice was given to affected individuals or groups?
The notice of rulemaking hearing was posted on the Tennessee Secretary of State's website on September 12th, 2014, and it was posted on the Tennessee Collection Service Board's website on September 16th, 2014. Additionally, for licensees who have opted under TCA 1306D to receive electronic notification via email of changes which may affect their license, the email opt-in notice, which included a link to the notice of rulemaking hearing, was posted and sent on September 19th, 2014.
Thank you, Ms. Whaley. I will now read the substance of the proposed rules into the record. The proposed rules are somewhat lengthy, and I'm authorized to summarize them, so I will do that. And if the board members have any questions, I will be happy to entertain them at the conclusion. The first amendment is to Chapter 0320-01 regarding licensing, and the amendments to that section are as follows. Again, as required by legislative action, this proposed rule change implements an expedited licensure process for members of the military and their spouses. In all candor, this is very unlikely to apply very much, if at all, to this board, given that this board now licenses solely agencies, which are corporate entities and not individuals and things of that nature. However, in the event that that should change, this rule will be in place and available to members of the military who might need to avail themselves of it, and also could allow for some consideration for officers and whatnot in the renewal of licenses. The other amendment to this particular rule is to delete the requirement in the application for licensure of the location manager. And then next is Rule 0320-01-.02. That rule discusses examinations for location managers, but since that requirement no longer exists, that rule is amended by deleting it in its entirety. And finally, Rule 0320-01-.03 regarding fees. Paragraphs number 2, 3, and 8 addressed the fees that were applicable to the location manager and the requirement of fees to be paid by the agency for the location manager. Those are being deleted as well. At this time, I will entertain any questions that the board members may have about these rule changes, and if there are none, then I will move into the other requirements for the record for this hearing.
We have sole proprietors as agencies, a sole proprietorship as opposed to a corporation, LLC, or some other entity?
It is possible, but very rare.
That would be the only time when that rule would really apply. If a sole proprietor was a military person, then it'd be bumped. Otherwise, an entity, it wouldn't.
That's correct. And
Curious.
no, it's a good question, and this requirement from the legislature is applicable to all regulatory boards in our division, so this board is not the only one that has had to implement a rule change regarding that. So,
No other questions, please proceed.
okay. There are 3 things that have to be read into the record regarding any proposed rule change. There is a regulatory flexibility analysis required by TCA 4-5-401, the economic impact statement as required by TCA 4-5-403, and the local government impact statement as required by TCA 4-5-228. And I'll start with the regulatory flexibility analysis at this time. Regulatory Flexibility Act at TCA 4-5-401 and subsequent sections requires that prior to initiating the rulemaking process pursuant to TCA 4-5-202A3 and -203A, all agencies shall review proposed rules and the effect that the proposed rule has on small businesses. The Act requires that each agency shall employ a regulatory flexibility analysis utilizing regulatory methods that accomplish the objectives of applicable statutes while minimizing any adverse impact on small business. The Act further provides that the agency shall consider without limitation certain methods of reducing the impact of the proposed rule on small businesses while remaining consistent with the health, safety, and well-being of the public. And those methods are as follows. The extent to which the rule or rules may overlap, duplicate, or conflict with other federal, state, and local government rules. The clarity, conciseness, and lack of ambiguity in the rule or rules. The establishment of flexible compliance and/or reporting requirements for small businesses. The establishment of friendly schedules or deadlines for compliance and/or reporting requirements for small businesses. The consolidation and simplification of compliance or reporting requirements for small businesses, the establishment of performance standards for small businesses as opposed to design or operational standards, and the unnecessary creation of entry barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase costs. The description of the proposed rule has already been read into the record, but again, this is regarding an amendment to the Collection Service Act, which deleted all references to the location manager requirement, and then a 2014 legislative act that required a rule for the expedited license renewal for certain military personnel and/or their spouses. The regulatory flexibility analysis is as follows. Number one, overlap, duplicate, or conflict with other federal, state, and local government rules. There is no overlap, duplication, or conflict with other federal, state, or local government rules. Clarity, conciseness, and lack of ambiguity. The rules are clear in purpose and intended execution. Number three, flexible compliance or reporting requirements for small businesses. These rules do not create any new compliance or reporting requirements. Number four, friendly schedules or deadlines for compliance and/or reporting requirements. The proposed military applicant rule will expedite the licensure process for certain military personnel and/or their spouses. Otherwise, these rules do not set out new compliance or reporting requirements. Number five, consolidation or simplification of compliance or reporting requirements. Again, there are no new compliance or reporting requirements for these rules. Number six, performance standards for small businesses. These rules do not set out operational or design standards, and as such, there are no performance standards imposed as a result of these rules. And number seven, barriers or other effects that stifle entrepreneurial activity, curb innovation, or increase costs. It does not appear that these amendments will erect any such barriers or increase costs. On to the economic impact statement. The economic impact statement requires that the following factors be considered, and the analysis for each of the factors is as follows. The type or types of small businesses and identification and estimate of the number of small businesses subject to the proposed rule or rules that would bear the cost of or directly benefit from the proposed changes. Collection agencies, especially those run as sole proprietorships by members of the military, would benefit from the military applicant rule due to the expedited license renewal process. Additionally, the location manager requirement being removed will result in a somewhat lower cost of doing business. Number two, the projected recording, record keeping, and other administrative costs required for compliance with the proposed rule, including the type of professional skills necessary for the preparation of reports or records. The projected administrative record keeping or recording costs are expected to be minimal or non-existent. Number three, a statement of probable effect on impacted small businesses and consumers. The Statement for that item is the same as number 1 regarding the benefit to members of the military and a lower cost of doing business. Item number 4, a description of any less burdensome, less intrusive, or less costly alternative methods of achieving the purpose and objectives of the proposed rules and to what extent those alternative means might be less burdensome. This item is not applicable. Number 5, a comparison of the proposed rules with any federal or state counterparts. This item is also not applicable. And number 6, analysis of the effect of the possible exemption of small businesses from all or any part of the requirements contained in the proposed rule. If collection agencies that are sole proprietorships run by military personnel were to be exempted, that would defeat the purpose of the rule change regarding the expedited license process for military members and or their spouses. And finally, the local government impact statement. These proposed rules are not expected to have any financial impact on local governments. Having now concluded the matters for the record, I will now ask that the board members vote on the proposed rule changes as set forth in the notice of rulemaking hearing, including the regulatory flexibility analysis, the economic impact statement, and the local government impact statement, and that they do so by roll call vote. Need a motion, second, and a vote to approve.
So moved.
Second.
Motion and a second. If we could have a roll call vote, please.
Oh. Bart Howard is absent. Elizabeth Trinkler is absent. Elizabeth Dixon.
Agreed.
Steve Harb.
Yay.
Chip Hellman.
Yay.
Motion passes.
Okay.
Thank you, members of the board. The proposed rule changes are hereby approved and will be sent to the Attorney General's office to be reviewed for legality. That concludes the rulemaking hearing. Thank you.
Well, with that completed, we'll move on to our normal board meeting agenda. You have the agenda in front of you. Do I have a motion to approve the agenda?
So moved.
Second.
All in favor? Aye.
Aye.
Okay. So the agenda has been adopted. You also have in tab 1 the minutes from our last meeting. I will give you the opportunity to review the minutes, and ready, I'll take a motion to approve the minutes.
Do you need to read the thing into the?
I already did. The notice?
Sorry.
It's okay.
Motion to approve the minutes.
So moved.
Second.
All in favor, say aye.
Aye.
Aye. Okay, the minutes have been approved. I'll now turn it over to Mr. Whitaker for our legal report.
Thank you, Mr. Hellman. Also going to be passing out one additional item that that came in prior or subsequent to this matter being uploaded to the iPads. I have that on paper for everyone, and I'll pass that out at this time. Board members should please take a few minutes to review the report, make any notes that you may have regarding questions, and then we will take questions at the end of that and make any amendments necessary and then approve the legal report.
Yes, Mr. Whitaker, I think we're ready for the questions.
All right.
On item number 1,
Yes, sir.
the passage of the new law to allow for not going after personal guarantees, did that come after this complaint was initiated or before it?
Did come after, however, in consultation with 2 levels of supervisors all the way up the food chain and analyzing the exact language of that amendment, it appears that it was intended to not only state what the law is going forward, but to restate what the legislative position in the law has always been, even going back.
Retroactive law?
It looks that way.
Wow.
That was my response as well in ways, but
Words that come after wow.
well,
actually.
not printable, but I'm sure there are. But so that is the reason for the recommendation. I did go back and forth with the Respondents' Council several times, and he pointed that section out to me. And frankly, prior to the passage of that amendment, I think there is a good faith, non-frivolous argument to be made that this board would have previously sanctioned such conduct. However,
Our old guys? I'm not supposed to ask that, am I?
well, that's about the time it happened, so you may
There's
draw
no
your own
license.
conclusions.
Yeah, the NA on the licenses. Yeah.
Yes, this is well, it's not the same entity, but it is an out-of-state company.
Well-written law, wasn't it?
Comment.
Thank you. Number 2, is $500 enough?
I believe it is, and for this reason, the the statute and the rules provide for a civil penalty of $0 to $1,000 for each violation. Generally, with an agency that didn't have any prior disciplinary action, there's at least a chance that this could go letter of warning. However, I did have some concern that it was not a ground level rep, but in fact a supervisor that admitted that X should have happened, but did not happen, and then on top of that refused to fix it. And it took the Respondents' Council to fix it. Now, the reason to go with the 500 is, at least in my evaluation, once it got to somebody who recognized what should have happened and how this should have gone, it immediately got fixed. And I think that is worthy of consideration. I mean, I think it'd be different if the council was like, no, I'm just going to defend my person, and they just did what they did. But that's not the case. The council was very upfront and said, this is not the way it should have gone. This is the analysis that should have taken place, and it didn't. We apologize, and we have fixed, this particular matter. However, I still believe a consent order and a civil penalty is appropriate given the facts.
The reason that I take slight exception is it went to a supervisor who finally saw something, but going a little further back up into it, where the IT glitch and they never got their initial letter, the agency realizes it made a mistake, didn't send the original letter, and still pushes, do you have to approve it before I take it off? I think that's a step too far. The agency made a legitimate error, and they should have backed off until the person had the opportunity to have their right to complain. I'm a member in industry too, and I feel pretty strongly about that. So I agree with what you said, that the right person finally said something, but the indication is if at the lower level, the number of times it's going on and people are getting pushed too far, that bothers me a little. Had they not made the IT glitch, had they sent the original letter out, yeah, everything's fine. But how many other IT glitches and how many other people didn't get letters who were pushed? I think you're letting them off too light. That's just my opinion. Because of the IT glitch.
No, that's that's why these things are presented to the board for discussion to be had and opinions to be expressed. And if the board so feels, this can go up to $1,000.
So, Mr. Harb, do you have a recommendation?
Can I ask you a question before you do?
Yeah, sure.
Have there been any prior problems with this company?
Not of this nature.
There been other nature.
Well, that's
Yeah.
well, that's not a completely fair question from the standpoint that the larger an agency, just by pure statistics, there will be complaints. So you can't go based on, number of complaints someone has received. I typically go by how they were resolved and was their disciplinary action taken. And so I didn't see anything like that in terms of any discipline taken for this type of matter for this agency.
The agency had complaints based on errors they had made in the past, as this one is.
None that could be substantiated. I mean, it's gone through whatever complaints prior are what they are, and they've gone through the process and been disposed of, and that's really all I can tell you is that nothing that resulted in a consent order or a formal hearing where they were sanctioned.
Were there any civil penalties involved?
Or
In any prior cases? In any prior cases?
I would have to see if there were on different issues other than this one. I really was just kind of looking back to see if there was anything prior that it sounded or looked like this. So,
By the way, I completely agree with your analysis, had there not been an IT glitch. But the IT glitch is too big. They never got the opportunity to respond. Not responded, then the person's response of you got to prove it first is completely valid.
and my other concern is that when the IT glitch happened and that first notice didn't go out, a timely validation notice did get sent by the consumer, and this conversation with the supervisor that took place where they said, yeah, our bad, but not only we're not going to do this, but you got to prove it first, that took place within the time frame for timely validation. So while the consumer was in the posture of trying to exercise their right to validate the debt, you have an admission by a supervisor that, hey, this is what should have happened and didn't, but, not so much.
Mr. Hard, would you be more comfortable if this penalty was $1,000?
I don't think the monetary penalties, I think they need a strong admonishment that if they find that someone hasn't received the proper notification, they need to back off until they can validate it themselves. To me, they just pushed a little too hard.
That language could be included in a consent order with the $1,000 civil penalty.
That's all we can do. That's all we can do.
Would you like to amend this report?
I'd move to amend it to give them a stronger reprimand of their actions based on their IT glitch and their response to it, and to up it to the 1,000 to the maximum.
Oh, if we need a motion in a second for that, do we? We're going to approve the whole report with this with any other changes in this change at the end. Is that correct, parliamentary wise?
Now, what you can do is, if that is the entire board's feeling, just do a motion to amend and do the vote, and then we'll vote to approve the whole report as amended at the end.
Are we allowed to discuss it at all? In front, on camera and stuff? I mean, I just wonder what the other folks feel about it. Am I being too
You can
hard-headed?
Discuss
I
it right
think-
now if you feel like it.
First, before we discuss, there's a motion. Do I hear a second?
Second.
Okay. Now we can discuss that. I feel the same way. I'm going to vote yes for this change.
Had they not made the mistake themselves that caused the problem or could have led to the problem, then their position was just fine. But, okay, thanks.
Are you ready for the question for this amendment? All in favor, say aye. Aye. Okay, so we've made that amendment. Correct me if I'm not doing it, we got to do this right. But are there any other questions or comments regarding this report? I'm going to ask a question. Do we I notice there are at least 2 voluntary surrenders in here. Are we have we ever tracked the voluntary surrender of licenses? I think there's a contraction going on in the industry that ultimately is going to impact our budget, I think, over time. We know we're losing the location manager revenue, and there are going to be companies consolidating as well as those who are just opting out of the industry. And that's sort of a nationwide trend because of the impact of the Consumer Financial Protection Bureau, and the regulatory requirements are just growing, so the small companies are struggling to keep pace. Do we track any of that? Have we noticed any increase? Is it just kind of coincidence that on this report there are 2 companies surrendering their license? Is there any data for us?
There are also going to be surrenders based on the debt buyers not having to be licensed if they outsource everything.
Right.
This year will be the first year of surrenders on that.
Yeah.
So, but didn't we get a report 1 or 2 meetings ago showing that licenses are up because you don't have to have location managers?
Right. We did see an increase in the number of companies that are making application. We're also beginning to see a trend, and we're coming into our renewal season, as you would call it, when the licensure was originally in December. The majority of the collection service companies renew December 31st of the even year. Actually starting to see the renewals come in, and we've actually seen a few more people not going to be renewing their license. So we're starting to track that because it is,
Okay.
We're seeing a little bit of a trend, and knowing that the legislation that just passed this past session, as Mr. Harb was referring to, we're going to see people surrendering and not renewing. So we are keeping track of it. I can certainly begin reporting on that monthly to let you know how many we've had over the course of a month, whatever you would like to see.
I don't think I think it's good to track it and report on it. I think it just helps us stay informed about the industry that we're helping to oversee. However, I don't think it's necessary that you send reports out between meetings, since we meet every other month.
Yes, of
Okay.
course. I'm so sorry.
That's what you
My
meant.
other board meets monthly, so I'm just in the
Okay.
monthly
Yeah, I'm
monthly
saying
cycle.
no extra work in terms of providing us with.
It'd be
their-
nice to know what you'd already put together about the increase in licenses. As of the first of the year, we had this many licenses. The law came into effect. We had an increase in licenses, and then we're now having a decrease.
Back and look, because the location manager was the session before, and the new law last session. So we're actually looking over, kind of almost the span of 2 years.
Right.
I can see the volume on my desk is definitely there's definitely an increase. It is kind of plateaued a bit. I'm not seeing as many come across for new.
Right. There was probably some pent up demand that once that change, I could see an initial push, but then on the backside, we have companies surrendering their license for multiple reasons. I think we ought to just be watching that.
Do we need a motion to approve this?
We need a motion to approve the legal report as amended.
And that includes number 14 that I handed out to you on paper.
Yes. It includes number 14.
So moved.
Second?
All in favor, say aye.
Aye.
It passes. I'll be darned. Okay, good. Administrative report,
Yes.
please.
On tab 3, you have your complaint, your complaint comparison report. I am happy to report that the performance measure is currently set at 80%, and we are at 95.59%.
Wow.
We're doing quite well
Congratulations.
with closing complaints within 180, closing or referring them for legal action within 180 days of receipt.
That's excellent.
No motion needed there, just for informational purposes. Next, on tab 4, you have, this is your current year budget. I will tell you, I don't know if it'll be your January meeting or your March meeting that will present the budget close information. has not told me which meeting. But I will definitely put it on the agenda.
Okay.
But what you have here is your current year-to-date through September.
Wait just a second, give us a chance to look at it. Mr. Harb, you're our resident financial expert. Is there anything here you'd like to ask about or inquire about?
Just looking for the revenue.
Oh, it should be on the third page.
Like I only have 2 pages. 3. It's
Top, tab 4. I have a printed.
tab right. Tab,
I can tell you what it is if that.
yeah, that'd be fine.
Okay. It's $69,673.06 year-to-date revenue.
Okay, we have that.
We have that.
Oh, okay. Is it the expenditures are missing?
Okay. Now, if this second page doesn't indicate that it's revenue,
Okay. My apologies.
so that's is that the net revenue or the gross revenue?
That's gross.
Gross. So, and our year-to-date cost is 28,000?
Yes, sir.
Okay. That first column was throwing me. The work plan of 321,000?
That's the budget, right?
Yes, sir. That's the budget. That's
For the full
That's
year.
the state term for budget.
We're way under budget, is that what this means?
As far as your expenditures,
Yes, ma'am.
yes. One thing you will notice, the salaries and wages, they fully fund any payroll, which the payroll there is $225,000. Currently only have 3 staff members on payroll, and you actually share those across with 4 other programs. But as positions are allocated to the board, the positions are.
Are they funded 4 times?
I'm sorry?
I guess I'm a little confused by
Oh,
that.
there's actually positions that currently are assigned to the collection.
Okay.
So when they create the work program, they fund it
As though those
full staff,
Okay.
which we currently have plenty of staff to do the work. Just historically, there have been other positions.
What happens to the additional funding at the end of the period? Is it turned back to the budget, or, like, right now, we're way ahead of the game?
Yes. No, it's on. Trying to think the best way to explain this. Because we are a different agency from the rest of the state because we are self-funded. The funding is they allocate that much of the expenses to us. So it's really, there's no real money there, but they have to say how much they anticipate us spending in order for it to be allowed in the accounting system for us to spend that.
Not efficient in governmental accounting.
Yet-
Never have been, don't want to be.
I'm sorry, but yet
It's okay.
most other state agencies are general fund funded. So at the beginning of the year, they're allocated a certain amount, which they are allowed to spend. They have to do the same thing for us, even though we are self-sufficient.
Okay.
It's a very odd, and we're
What
in a very.
happens with any excess funds that we may generate from our self-sufficiency?
Okay, the excess funds remain for the benefit of the board. But there is not actually 300. At the end of the year, it is your revenues less your expenses.
So we can't have a big party?
Okay.
No, but
The
the
answer-
remaining, the difference between your revenues and your expenditures remains for the benefit of the board, and it goes into your reserve account. In the reserve account, one of the things typically, we're not allowed to spend that money, but we are spending that money, a little bit of that money, to fund our new computer system. You'll remember last year when we did the budget presentation with then Assistant Commissioner Giannini about CORE, which is our new licensing system.
Okay.
So some of those.
What is our
excess-
reserve account? Do we have one?
We do have one, and I do not know what it is off the top of my head.
Is it bigger or smaller than $100,000? Yeah, it's okay.
I believe it's bigger than
Okay.
$100,000.
And what can we use it for?
Not anything beyond the computer system at this juncture. It is there for the benefit. For instance, this board typically runs a deficit every other year because of the swing with the bulk of the licensees renewing in December. So the reserve is actually there to cover that loss that you typically have. I will tell you this past year, you actually did close in the black instead of closing in the red as normally.
Why couldn't Bart go on that trip to represent the board?
The,
Yeah, we should.
I can speak to that. That is to do with the fact the position is the public members not travel to industry conferences, as well as we're still back to also the we're still evaluating. Your laws keep changing, so as far as what we project to happen, we don't know because we're coming into the renewal season as to whether you're will you see half of your licensees surrender their license and not renew? Because I actually will tell you that some of the people will choose just not to renew. They will not voluntarily surrender. Process.
So we're being fiscally conservative until we see what the impact of these changes have on our budget.
And Bart's a public member, not an industry member? Okay. That actually makes sense.
That does.
It's a combination of the
I just
two,
think that's right.
but that's been the administration's
Used to
position.
be an industry member, now he's a public member. Yeah.
Hey, do
believe
we
he
need
sold
any
his company.
sort of motion, or do we approve this? This is just
No,
information, right?
Just for information.
Okay, let's continue on to tab 5 and 6 then, please.
Okay. Tab 5 is actually a represent from last month where it was tabled. The first couple of pages are actually the new information that was presented, and it's not necessarily new information. They provided a little bit more in the way of background in their letter, but it appears that their balance in their trust exceeds what they owe their clients, which was the concern that this application.
Guys with negative equity.
Now, and within tab 5, if you look on page 4, up towards the top, there's a written notation that says that it has trust account balance. It looks like $287,000 and change. And then if you go to page 9, under liabilities and equity, accounts payable clients is $161 and change. So that was the information that we could not glean from what they had previously submitted, but now we can, and it looks like they're better than $100,000 to the good in their trust account.
Here's what's odd. When you look at our balance sheet, they put money market funds, $587,000. Cash in operations, $65,000. And of course, now there's a check mark next to cash and trust. Had they put the number for cash and trust there and reduced the money market, but is their trust account in money market funds? That's an interesting. I'm looking on our balance sheet.
So are you asking the question, are they sweeping that trust account each night?
Not that it matters. As long as they have the funds, and is it earmarked trust? I mean, it's pretty clear on our balance sheet that we have a line for trust account and a line for operating account. I mean,
Yes, And they actually completed the balance sheet form. I believe this is a new application. They just completed the form on their own accord.
And to your question.
They actually provided one of their filings. I believe it's I did not include this in your packet, but originally they had provided us their 10K.
And the bank statement information provided, the title and caption for that account is collection trust account. So it doesn't appear.
They're public?
I'm sorry?
They're a public company? If they did 10K? Yeah, that's fine. They were audited. It's fine. They have the money in trust.
Okay, do we need any sort of action on this, or is this?
Yes, a motion to approve.
I'll entertain a motion to approve this application.
Second.
All in favor? Aye.
Aye.
Tab 6.
Yes, tab 6 is also a represent from last month, and I would, this particular application actually has already been approved. The information came across my desk and it was not labeled. I've had a discussion with the staff about labeling the ones that have been before the board. But they did provide the information that was requested, which was a compilation report. Again, the first couple of pages, along with the information from the prior month's report. They had provided a letter stating they couldn't provide it. We sent them a letter stating please send it, and they complied.
Do we need a motion on this if it's already been approved?
I would prefer you just confirm it. I do apologize and have spoken with the staff. Just because of the way the motion was originally made, that it was tabled instead of upon receipt, please approve.
Compilation report looks good. Looks like a normal compilation report, and they have positive equity. Those are our requirements, and I assume that their trust is in. They don't show trust account in the compilation, but that's not necessary. They showed it on the back page, and it's in trust. So I'm good with it. If you guys are good with it,
Yeah, I'm fine.
Okay, I do need a motion just to confirm.
so moved.
All in favor? Aye. Aye. Okay. The legislative update on tab 7.
Mr. Hellman, if you'll recall, at the board's last meeting, Ms. Whaley and I advised that we would have something for the board to look at. Public Chapter 881, which was passed earlier this year, requires each program within the Division of Regulatory Boards to do a report on the feasibility of an apprenticeship program. There are several programs within the division like this one that really, frankly, doesn't lend itself to all that well. For some of the reasons we stated with the military applicant issue, it's hard to be an apprentice when we typically don't license individuals. So that is what we have as what's been submitted to the administration that's in tab 7. It just says the collection service license is not a professional license per se issued to an individual, and so basically our recommendation, because this report has to go to the legislature for them to look at and say, okay, do we want to do anything with this for certain programs? But our recommendation for this board will be that it's not really feasible, so we don't recommend one. And subject to any tweaks by the administration, and by administration I mean department, this is probably either exactly or real close to what will be submitted on behalf of the board for our reporting requirement. And so it's pretty straightforward, and I'll take any questions, but not really just a whole lot to explain here.
I have no questions. Okay. There are no other questions on that matter.
Okay.
The
Just a
Motion.
yes, just a
I
motion.
move that we accept or approve that this is not a board which would license individuals. It licenses companies. And we don't need an apprenticeship program.
All in favor, please say aye. Aye. Okay, and there's a firm license question?
Yes, this is sort of in line with the financial statement question because we're seeing large companies, when they submit information about their CPA, typically they're sending us their firm, a KPMG, a large group, as opposed to having an individual CPA prepare their financial statements. Accepting the firm being licensed is acceptable to the board, or if we need to the individual CPA license. Basically, the board's feeling on that and how we should proceed administratively.
I think I'm supposed to answer this. Generally, anytime a firm signs a report, an individual signs the report, our license requires the license number of a CPA. So if you look back at that other report, what number was that one we got on that compilation, for example? Let's under 7 or
Tab 6.
6. Well, the individual didn't sign it.
And just for historical reference, Mr. Harb, how the board has dealt with this before is, and obviously I don't have the expertise that you do, but I'm also counsel for the accountancy board. So
More.
as what I've seen is the bigger the company, the more typical it is for the firm to sign off on the financials as opposed to, an individual CPA audit or engagement partner or something like that. So if we've been able to figure they provide and or we figure the state license number for the firm that signs off on it, and they are signing on the bottom line as a firm saying that we sign off on this, then that appears to be a reasonable equivalent to an individual CPA doing the same thing, and for the same reason, because whether it's an individual or a firm, if something is misrepresented financially, then the purpose to that is to report that back to the state of licensure to let that regulatory agency do what they deem appropriate.
I'm real good with the firm signing off on it, but this was an initial application, so we don't have the place that says the license number of the CPA signing it on an initial application. I'm completely fine with the firm signing off on it, personally.
The statutory requirements have the CPA listed in it, even though it's not here. We asked them to provide it, and we actually do go in and we use the state verification system and verify each of the licensees that they provide us. The firm is acceptable.
I think it would be.
I agree. Do you need a motion to that effect?
I would prefer, if possible.
Motion that we can accept the signature of a firm in lieu of an individual CPA as long as the firm is a licensed firm, and that we can obtain the license number of the firm.
We have a motion and a second. All in favor? Aye. Okay. Tab 8 is an inquiry about a license requirement from a company that we won't name the name on record, but essentially stating that they do insurance billing for healthcare providers. They generate primarily their revenue from billing and follow-up of international medical insurance claims. The email, as I read it, goes on to say that when there's is a patient balance, they notify the provider and return the account back to the provider, at which time that provider has the option of sending it out to a third-party collection agency. So I'm paraphrasing, and y'all can read it for yourself, but the question is, are they required? They have no clients in Tennessee, but occasionally a consumer will move to Tennessee, is my understanding. So the question is, do they need a license?
Do they make the calls in the name of their client that they bill for, or in their own name as blank billing agency versus blank hospital or blank doctor? Do we know? I didn't.
That was my main question, and I don't see it as I've read in here.
That information has not been provided. I'd be happy to look into it. I actually have a little bit of experience in this field. This was basically the last job I did, and not exactly, but close enough. And at that particular job, how we would do it, and that doesn't mean that's how these folks do it, and I'd have to ask, but say, my name is John Smith with XYZ company calling on behalf of, provider.
That has a third-party feel.
Yeah, that's
Yeah.
the third
No,
part. They said, I'm calling from blank's office. If they're extended business office, a typical EBO, and they only represent themselves as being from that company, because that's the name on the bill, not their name, then I would say they don't need any license. But if they're not doing that, then they're third party. They're acting on their own behalf to collect it. So, yeah, I'd reach out and question that.
I agree with that.
Does your analysis change if the purpose of their call is not to collect any money? Because if I'm reading what they're saying correctly, and I can also confirm this when I speak with them, but the only reason they contact consumers is not to get money from them, but to obtain insurance information from them. Because even though...
It's also collection. It's
Well-
third-party collection.
Well, is it or isn't it? Because the person's insurance, is for their benefit, but I think it's a much murkier question than if they were calling saying, hey, look, I'm, calling, well, actually, if they were saying I'm calling on behalf of them and I want money, that's not a close call at all. But if they're asking for insurance information to process a claim, then, is that collection or is it not?
Collection, because any self-pay at the end of insurance, they already have the information to collect the self-pay. And any after insurance costs, unless it's Medicaid or Medicare and they're prohibited from collecting it, they are attempting to collect money, whether it's from the individual or from their agency. To me, they're collecting a debt. Now, are they collecting their debt or are they collecting the client's debt? If they're collecting the debt in their name, whether they're asking for insurance or your best friend to pay it on your behalf, to me, that's a collection call. So I would think it's pivotal that they call on behalf of the hospital or doctor. If they just say, I'm with the doctor's office, then that's not a collection call. But the way I read the letter, when there's a residual amount on the bill, they turn it back and it can be placed with an agency. That implies to me there was an effort to collect it, not just a number of days without any calls. And most billing companies do make some level of initial call. So personally, the only question is do they call strictly in the client's name? And if they do, no license at all. But if they use their own name, then they're attempting to collect a debt because they receive financial remuneration for the effort of collecting the debt. They get a piece of that bill for the collection, more likely than not. Some of them only get a percentage for producing the bill. That's a whole nother level of question.
Typically, they'll, in the insurance realm, whatever money from insurance is paid out, it's not that much different than a contingent attorney legal contract. You recover nothing, you get nothing. You effect payment from an insurance company, you get X percent.
If it's an attorney doing it, it doesn't need a license. That's easy.
That's true.
But if it's not an attorney, to me, they're collecting data that's going to be valid down the road when they have self-pay off the back of insurance, or if insurance is denied. And or it could be a front-end scam saying, I'm collecting for your insurance when they're really trying to gather the personal data. So I just...
The final paragraph, of course, I'm riddled with this code. To send a third-party collection agency. Firing here.
No, I think that's probably a good idea because it's not their, as I understand it, it's not this company's debt, so it's not their call as to whether to try to collect self-pay. It would be the original creditor, which in that case would be the healthcare provider. Whether it would be their call whether to do their own in-house patient collection or not.
Personal belief is if they are contacting consumers in a third-party name to collect a bill, they need to be licensed. That's my personal opinion.
Using the name of their client through the billing company, no requirement.
That seems pretty clear.
Yeah.
So is that in the form of a motion that if they're calling only in the name of their client, no license, if they're not licensed? Is that a fair representation of?
Yes.
You can make a motion.
If I'm allowed to make a motion, I'll make that motion.
Since you're chairing, I'd let Mr. Harb do it, and then you can just vote.
Make a motion as you described it. If they're calling and using their name and calling, then it's an attempt to collect a debt and they need a license. If they use the name of the patient office or the name of their client only, then no license is required.
All in favor, please say aye. Aye. Okay, we now have the section on the agenda for new business, and might that include any guests? Is this the time where we would, is there any sort of communication, or how do we set this up for particularly for the benefit of those who might be watching this later that don't know what we're doing here? What do we need to do properly to allow them to speak?
If the board would like to hear from our guests, just simply invite them to the podium, ask them to identify themselves for the record, and then discuss away.
Okay, so we have guests. If you'd like to appear, we don't actually have the podium set up, but if you'll sit by the microphone, properly identify yourself, who you represent, name of your company, and so forth, and what you'd like to talk about.
Good morning. My name is Debbie Rust. I represent the Tennessee Collectors Association. Our association has brought some concerns to our board in regards to debt consolidation, debt counseling, and debt repair companies. It seems that there is a bombardment of from these type of companies to agencies here in Tennessee, apparently nationwide, but I'm concerned about members of the Tennessee Collectors Association. What's happening is these companies are promising consumers a service of credit repair, and they contact the agencies representing the creditor, and what we're finding is a trend of constant communication from these companies that I do have examples where they are dating a letter, demanding validation, demanding particular information if the demand is not time that they have requested it, which is usually 30 days, which there is no law stating it must be responded to in 30 days, just a timely manner, which is generally. But what they are doing is they are holding this data. They'll date a letter, for example. I have one here from a particular agency here that is dated July 18th, and the envelope was not dated by the postmaster or postmarked until August, with demands that this be responded to in 30 days from the date of the letter, or it must be the consumer's credit. They are also now stating that if there's additional communications on this debt, there will be a $2,500 fine imposed. There will be, if this proceeds to legal action, there will be a $5,000 fine imposed. Well, they can't impose a fine against an agency. They're not in a position to do so. So they are not only misrepresenting themselves to the consumers as to what they can accomplish, because if a debt is valid and validated, it's fair credit reporting. And then in addition to that, they are not following through with, again, their promise to the consumer, and the fact that they are not allowing the time that they are demanding and putting additional demands on these agencies, again, that lawful demands. We have numerous examples from numerous agencies in national, and these agencies are getting 600 to 800 of these a month. It's costly to the agencies. It's time consuming. It's situation where, again, with their demands, you can't meet a demand in 1 week for a 30-day demand when they're, and once again, these constantly are coming in with the same dates, apparently the same signature, but a different consumer's name, and the exact same envelope with the postmark 2 to 3 weeks after. For example, the company I work for, Robinson, Reagan and Young, we are a law firm. Apparently, they're getting data off of a credit bureau, and they've addressed every one of these letters to Robinson, Reagan, and you. They are not even really investigating what they are requesting demand for validation on. And then when we validate this debt, we get numerous contacts from consumers complaining that we have to remove these from their credit bureau. They were instructed by the company they paid for credit counseling and credit repair that we would be removing these once they have paid this and satisfied the debt. The only time you can remove something is if it is erroneously reported. Hence, it is not fair debt credit reporting. So we then have the struggle of constant complaints and disputes coming into boards like yourself or to the Better Business Bureaus, maybe even CFPB at this point, stating that we are not removing a debt from the credit once it's paid because that's what other companies are informing these consumers of. And that, again, is not fair credit reporting. We have to mark an account as paid in full once it has been paid, not remove it. In credit scoring, that is part of the reason in reporting is that, once again, to get an accurate depiction of the consumer's credit history. And so if they know that they can pay, I'm going to pull a company out of the air, Comcast, get their services on, not fail to pay them, and then at Christmas decide to get cable for their children and pay that debt, let it accrue another bill and rack up let it be turned over to collections again. It gets on their credit report again, but they pay it again, comes right back off. It tends to be a consumer trend and cycle for continually using that system just as either their personal finance or as a way to delay paying because there is no consequence. So of course these on their credit. But the concern is more so what's being promised to the consumer, and then of course the challenge incurred by the collection agencies trying to follow regulations, properly report to credit, properly respond to consumer requests for validation when we're being overwhelmed with demands that are they're not even able to be responded to in the time demand that we're given.
Can I ask you a couple questions? Maybe make a few comments. My first question is, I guess the comment is that we're all aware that these debt consolidation firms are creating a sort of a nightmare for the industry, and that's nationwide, not just Tennessee, just obviously. But my first question is, what would you have us, why are you here to speak to us?
Perhaps we are looking for some guidance or direction into a resolution to this, whether it's regulating, putting some type of regulations in place as to how we would on the collection agency side, maybe even try to get some type of resolution to this.
Ms. Rust, if you would just try scooting your microphone a little closer, it may stay on a little better.
Okay, thank you. But like I said, perhaps just some guidance in where to proceed with this.
Can I ask just a couple more questions? And then I'll continue to make comments, and I'm sure my colleagues will as well. But has the Tennessee Collectors Association retained any outside counsel experienced in CFPB, FCRA, or accounts receivable management matters to research and advise the association on how to respond to these? And let me, before you answer that, say that some companies now, some of the large market participants, have decided based on counsel they've received that they won't respond to anything received from a debt consolidation firm for fear of lots of things. One is creating the nightmare cycles that you've described, but number two, potentially violating the improper disclosure of the debt to a third party. They're doing it, though, not just because the CEO woke up one day and said, we're not going to do this anymore. They did it after seeking counsel from, there are attorneys around this country who understand the regulations intimately as opposed to just a general lawyer who may know corporate matters. So my question, I'll restate it, but have you retained the services of your association of any expert counsel in this?
As of now, we have not. The National Association, ACA, the American Collectors Association, starting to pursue legal advice on that. Again, our members have discussed this at our meetings, more concerned with Tennessee and what we can do here for our members.
The issue that I see, but we have an attorney here who can correct me, but we're charged with regulating the collection industry. And because debt consolidation firms don't fall under our authority, if you will, there's really not much we can do except sort of tell you what we've learned in talking to people from other states. Your FCRA matters, that's a matter of law and rule. And you've signed an agreement with the credit reporting agencies that tells you how to handle certain things like a paid account. And you have an obligation to do that correctly, or you could lose your ability to to submit data. So I don't want to give you any advice because I don't really have any other than it may be time. I do know the name of some good attorneys around the country who would be able to look very specifically at these matters and advise your collection agencies within your association as to how they would recommend, based on case law and the laws themselves, how they would suggest you respond to these types of requests.
And we were aware, of course, that they are governed under another board. Our intention was to perhaps prompt something on the service boards and to provide guidelines for Tennessee agencies to respond to these. I don't mean to use a loose term, but we might be barking up the wrong tree, but we're at least trying to get your advice and direction as to how to handle the matter. So.
Mr. Hellman, before we move to Mr. Harb, you raised something that I actually can address and that Ms. Rust referenced. The regulatory board's title in Tennessee Code is Title 62, and Collection Service Act is Chapter 20, so it's 6220, so on and so forth. Department of Commerce and Insurance title is Title 56. The debt management and credit counseling companies, such as they are in Tennessee, are regulated under Title 47, and that is the consumer affairs folks, which is not us. So there is a concern, and I think both of you referenced it, albeit from maybe different perspectives, that when the legislature undertakes to regulate something, a business, an industry, in one title, it can generally be presumed that they are doing so to the exclusion of elsewhere most of the time, unless they make reference to it. Like if Title 47 says, okay, we're going to do all of these things, and then as provided for in Title 62, read that and we're doing this too. So depending on what the request is and what the board felt about it, there would have to be some research done to determine whether the board even could do its authority under Title 62. That hasn't obviously been researched yet, because this is kind of a, just got this to be looking at and considered. So it'll be up to the board as to whether you'd like me to look into it more. So that's kind of to your point about what Tennessee law says about these kind of companies right now. And the other thing that I would just put out for the record, and again, I'm obviously even more so than Mr. Hellman being the board's attorney, I can't provide advice, but just a cursory look and my familiarity with at least the FDCPA doesn't seem to indicate a requirement that any collection agency communicate with a third party credit counseling organization or whatever they call themselves, because most of the reporting requirements as I see them as between an agency and a consumer are between the agency and the debtor, not the agency and the debtor's agent or power of attorney or whoever they hire. The main exception being if they actually do retain a licensed attorney and the agency knows about it, they may not go around
Right.
the attorney to talk to that debtor. But otherwise, I think it could be interesting and illustrative for any agency who receives a demand from a company of this nature, especially when they're saying, oh, if you don't do this, there's going to be money penalties. Okay, well, under what federal or state statute or regulation do you propose that this is going to happen? I mean, that seems like a decent first question, and then whatever they say in response is whatever they say.
Right. At the same time, I know some companies are electing not even to ask that first question because they're just ignoring. If you would like to speak to the board, you'll need to come up and identify yourself. There are 2 microphones there, so you.
You got one. Hi, I'm Becky Givens, and I'm with Fox Collection Center in Goodlettsville. But the question, Mr. Whitaker, that these are not, they have the appearance of coming directly from the debtor. They're not coming.
Hold the microphone up, please. You slide it or move your chair over.
I
in
think
front.
this is it. Okay.
Okay, you can move your chair, though.
Okay, I'm fine. The letters come with the appearance of being directly from the debtor, not from a company. So does that make a difference? We know that they're computer generated, but they have no reference to a debt counseling.
I cannot and won't provide legal advice, but I can tell you based on my consulting work in the industry across the country is there's some logic being applied by some companies to say if we receive 30 letters today with the exact same date, the same letter, exactly word for word, same print style from 30 different consumers, we know this came from a credit repair organization and we are not going to answer them. That's what some companies are saying. I'm not suggesting that that's what you should do. My only suggestion is you should hire good, competent legal counsel to advise the association on a standard response to such inquiries, which is way outside of what we do here. That's my opinion. Mr. Harb, I'm sorry if we...
Oh, no. What you've said, my question really, you've explained it, that the letters come the way they come. It would seem the place to go, and this is just a layman's viewpoint, would be to the CFPB, the Consumer Financial Protection Bureau. It seems like your association may want to file a complaint with them because that's what they're there to do, protect the consumer. And I know you're a collection agency, but most agencies don't want to do harm to consumers. They just want to collect the debt. and this is doing harm to the consumers. So perhaps complaining to the authority would be the right place to go. I mean, I agree, this is not something I think our board, as you pointed out by the titles, covers, but why wouldn't the CFP be, if you could get somebody's ear over there?
I would also suggest the state.
With a good attorney.
Yeah, with a good attorney, and I would also suggest our own state of Tennessee Attorney General's office. Remember, you guys are getting complaints from the Attorney Generals on behalf of the consumers, but that would be another way, again, with from the advice of counsel, but maybe being proactive and telling them, we have a problem here. We know that we're running a risk here of harming consumers, not because we've tried to, but because of these repair organizations, and we don't want to harm consumers. We
also know they're getting scammed.
Yes.
The consumer's
Right.
getting scammed. It's pretty
Exactly.
obvious. You know, I mean, to the extent we can step up and protect the consumer, I think we ought to.
Right, and these companies charge the consumer. We've done a little bit of research, and they have a monthly charge to the debtor, which to us is not fair to the debtor either.
An interesting complaint for us to complain about protecting consumers, but
Well,
it's a rational
it's-
complaint because they're getting hurt.
Right.
Well, and the last piece that I would add to that is, since Consumer Affairs actually handles the registration, and there are some requirements as to what these type of companies may and may not do. Not being their counsel, I couldn't begin to tell you what their enforcement authority is or is not, but there would seem to be a list of things they can and cannot do, and if the conduct that you're complaining of falls into one of those categories, as qualified counsel might explain it to you, or your research could ascertain, then again, in the interest of being proactive, that might be another avenue to consider, especially considering that that's who handles the registration for these type of businesses right now.
Good to know we're hearing from the field, and we really appreciate your
Yeah,
presence. We really,
absolutely.
because we are not aware of the market forces always. Some of us on the board are not, as Chip is, but thank you for coming.
Thank you for speaking with us.
Is there any other new business that anyone's aware of? Is there any old business that maybe didn't make the agenda or?
I'd like to make a motion. We adjourn.
All right. We have a motion to adjourn this meeting. Do I hear a second? Do we need a roll call vote for that, or can we just, all in favor, say aye? Aye. We're out of here.
Good job, Chip.
Yeah, thank you all for